That's the weakest, most illegitimate legal argument ever.
We are the Armed Attorneys. Today we're talking about a recent court decision striking down the inability of 18, 19, 20-year-olds to purchase handguns. It's an important decision going forward for the future of our Second Amendment rights. But before we get started, show your support for the Second Amendment by hitting the like button. And today's episode is sponsored by Sonoran Desert Institute. If you're interested in armor courses, gunsmithing, and so much more, head to www.sdi.edu/arm-attorneys. You'll see the link posted below. Give them a shout. They're great. And thank you, SDI, for sponsoring this video. So, Edwin, what are we talking about today?
Well, we are talking about a case that is about a month old. It came out of the Eastern District of Virginia, and the case is Fraser versus the ATF. And what is interesting about this case is, number one, it kind of shows us the expanse that courts are now using the Bruen decision to attack these gun laws. And it's interesting because it attacks one of the oldest, most fundamental gun laws in the United States. It's a gun law that was part of the original Gun Control Act of 1968, and it was made as a political decision where the Congress decided that an 18, 19, 20-year-old could buy a rifle from an FFL, but he could not buy a handgun from an FFL, and that's because, just to give people kind of a little historical context, the reason that the gun control laws were created when they were was because legislators had a fear of handguns.
In all fairness, lots of high-profile political figures getting killed circa 1968. So, I mean, you think the high-profile people in office are like, well,
yes,
I'll pass some laws to protect my own skin, right? It doesn't make it right, but like that's what we know what was going on.
Yes, and like I said, they were afraid of the handguns, and particularly the Mr. Saturday Night specials. Because they have a barrel that is blue and cold. Those cheap handguns, they really wanted to try to regulate. Now, of course, it's all about the semi-automatic rifle. And so... But
because the boogeyman of the day will change depending upon what we're all scared of underneath our beds in the moment. So right now...
Yes, and that's what makes this case really interesting, in that it is analogous to the fights that we're having today in today's society that are these raise the age bills. Obviously, in Texas, we had a major fight this legislative session over raise the age to purchase a semi-automatic magazine-fed rifle. And the logic is the same. They're saying that an 18, 19, 20-year-old doesn't have the maturity level, they don't have the brain development. So it's the exact same argument. So if this court is going to go back and strike down a 50-plus-year-old law regarding age restrictions, then I think it's very apt to go and say any new law restricting the access to rifles would be struck down as unconstitutional as well.
Yes, and this is when Bruen came down last summer, and we were all so excited. And then, I guess probably looks to the general public like, well, what did Bruen really do? Because all of these state legislatures are continuing, and of course the ATF's doing what the ATF does, but on all levels, the government is still restricting Second Amendment rights. So I'm sure there are a lot of people out there saying, well, what was even the point of Bruen? This is the point of Bruen, right? Yes. Because you can pass these laws all day long. The ATF can rewrite rules, can shove things down our throats, but ultimately everything is going to have to go through this test. And I know Edwin Walker wants everybody out there to sit down and read 70 pages worth of legal writing.
They can do it, right? I mean, this is a fantastic opinion for historical analysis if you want to read it, because it talks about, are 18, 19, 20-year-olds part of the people? Are they part of a political group? It does a lot of historical analysis. Of course, remember, I want to caution everybody, this is just simply the opinion of one district court judge in one district. It will face scrutiny by the Fourth Circuit Court of Appeals, which traditionally has been an anti-Second Amendment circuit. They've upheld everything that comes out of the state of Maryland, which is ridiculous. And so, but it is such a fundamental law, and it has been on the books for so long, that this case very well may wind up in the U.S. Supreme Court for analysis.
I think it likely will. So yes, if you are curious about what Bruen actually means, this is a good case to show you the kind of scrutiny that every single anti-gun law is going to have to go through from this point forward. We will drop a link to this opinion in the description below if you have the time and inclination to go through it. But practically, what is the effect of this court making this decision? Can an 18-year-old in California go buy a handgun right now?
No, they cannot. So this is limited just to the jurisdiction that put out this ruling, which is the Eastern District of Virginia, and specifically with regard to the plaintiffs, although the plaintiffs did sue on behalf of all other 18, 19, 20-year-olds. So it will be interesting to see. This court pulls other decisions from other states. For example, Texas. You know, we had our fight here in Texas about allowing 18, 19, 20-year-olds to constitutional carry. That case is cited in here as support for the decision that the 18, 19, 20-year-olds are a group of people who are contemplated under the Second Amendment. And I just want to say that whenever you're arguing with any of these anti-gun people who say that an 18, 19, 20-year-old is not developed enough to be responsible to handle a firearm, that's the weakest, most illegitimate legal argument ever, because all you have to do is look at our criminal statute. If we're deciding that an 18, 19-year-old has the ability to know right from wrong, because ultimately what they're trying to prevent is murder and assault and armed robberies, the age of juvenile competency is 10. The age of criminal responsibility for adults is 17 in most states. And so, of course, an 18, 19, 20-year-old knows the difference between right and wrong, knows that they're not supposed to use a gun to murder people. And so there's no logic in saying that the age to purchase either a semi-automatic rifle or a handgun has to be 21.
Correct. So, good news for the Second Amendment. We like to bring you good things, not just sort of the doom and gloom that's happening across the country and through the federal government a lot right now. Take a look and just remember that, yes, we are having to fight this battle. I mean, we're going to have to fight it, particularly in anti-gun states, but even in states like Texas, they're still trying to pass anti-gun laws.
I know.
It's a fight that we have to undertake. If you want to help contribute to that fight, we always recommend joining your local rifle associations, Gun Owners of America, Firearms Policy Coalition, Second Amendment Foundation, etc., etc. Those are great groups who are fighting for your rights every single day. Thanks for watching. If you like this video, consider subscribing and help us fight the anti-2A algorithm by sharing this video. Thanks again to SDI for sponsoring this video. Check them out at sdi.edu. And until next time, we're the armed attorneys. If you like this video, consider subscribing and help us.